Welcome to HAKAM's Ask Me series here live on Facebook. I'm Chacko Vadaketh, and this is the second installment of the series. Last week we had Dr. Ambika Srinivasan on Facebook Live answering your questions that you had posted on the HAKAM Facebook page. Today we are privileged to have Steven Thiru, the president of the Malaysian Bar, here with us for the second installment. HAKAM is the National Human Rights Society of Malaysia, and the Malaysian Bar is a statutory body mandated to administer the legal profession in Malaysia. They are also mandated to uphold justice without regard to the interests of its own interests and the interests of its members, and without fear or favor. So today we have Steven Thiru, president of the Malaysian Bar, and he's here to answer the questions that you've posted on the HAKAM Facebook page. Please share this feed on your own pages, tag friends of yours that might be particularly interested in this. We want as many people as possible to benefit from this very special opportunity. Welcome, Steven.
Good afternoon, Chacko.
Or rather, thank you for letting us invade your office at the Malaysian Bar.
Not a problem at all.
And to answer these questions that we've had on our page. To jump straight in, the first question that we have is, there is a proposal by the government to amend the Legal Profession Act, which appear to have the effect of curtailing the independence of the bar. How can the Malaysian Bar stop the government from interfering with its actions, its elections, business, and generally its independence? Is there anything that the members of the public can do to help protect the Malaysian Bar's independence?
Thank you, Chacko. Well, that's really the mountain that we face at this point in time. These proposals have just come from government. And it's not finalized yet. We are still discussing. We are hoping to persuade government to drop the proposals. But can I just briefly tell you what the proposals are?
Yes, please. I think all our viewers want to know.
Proposals are broadly one. Government wants to nominate 2 members of the bar to sit in the bar council to represent government. So in other words, you have these 2 members who are purely appointed, not elected, and all our council members are elected today, and I must say elected on merit. And if they have reporting functions, it means that our proceedings would not be confidential, and these members would be able to really speak outside the meetings, and they could differ openly with the positions that the bar takes, and that could result in 2 voices speaking for the bar, basically. And that's really not something that we want. Secondly, government is looking at increasing our quorum requirement for our meetings. At the moment, it's 500 members to achieve quorum and convene a meeting. The thinking is that it should be, or the proposal by government is that it should be increased to 25% of the membership of the bar. The membership of the bar today, ladies and gentlemen, Chacko, is 17,000 members. So 25% would mean we will need 4,000 members to turn up before we can convene a general meeting.
Such a book Stadium Merdeka or something.
Something like that. It's definitely going to be an outdoor meeting. It's no longer going to be an indoor meeting. But that's really a nigh impossible number to achieve. And there's of course this misunderstanding that quorum means representation. Quorum simply means a number that an organization is comfortable with to start a meeting, and then the meeting progresses and other people would come. In a typical Malaysian bar general meeting, 500 is how we achieve quorum, but as the meeting progresses, we would have anything up to maybe 1,500, 2,000 members. That's not about representation. That's about the business of the organization. If you're talking about representation, then really it should be 50% or more of the bar, and we're certainly not advocating that. I think the 500 number that we have now is a good number, because it's a number that both government and the bar agreed to in 2006 when we had that problem at that time, and we needed 1/5 of the membership, and the membership was much smaller then. But to have this proposal on the table is really a means to punish the bar, because if we do not have, if we do not get the quorum, AGM can't be convened. If the AGM cannot be convened under the LPA, the Bar Council does not take office. And if the Bar Council does not take office, there are severe and serious ramifications to the profession. Because one of the things that the Bar Council does is we issue the Sigil Annual, which is required before members can get their practicing certificates. If there's no Bar Council and no Sigil Annuals are issued, then that members can't get their practicing certificates, and that's the matter that affects their livelihood. Then the third major proposal that we have in mind is to revamp our entire electoral process. And again, the thinking behind this is very unclear because what they have in mind is to have elections strictly along state boundaries. We today have two levels of elections, one at federal level, where any member of the bar would have maximum of 12 votes. You can nominate the vote for 12 persons. And then a second level where you vote at your state and you get to vote another 2 persons. It's a chairperson as well as a rep of the bar. So that's 14 votes that you get. Under their proposal, it's reduced to 3 votes per member and confined to state boundaries. That's again a very unhealthy practice because members must have a choice of voting for candidates to the Bar Council that are outside their own state, somebody who they think who's talented, who's doing a good job, can contribute to the bar, and they should not be forced to just vote for candidates within their own state. So that's the problem that we have with the proposal on the electoral process. And then the other proposals are, one is to have direct elections for the office bearers, and that's put down as, this is a matter of popularity, but the bar is a professional organization. We are not a political party. Yes, popularity is one element, and members get elected to the Bar Council, but it's really the work that we do in your professional capacity, sitting in council, and it cannot be just a matter of who is popular to sit in the Bar Council, and certainly who is popular to lead the bar. The mechanism we have now is a very workable, time-tested mechanism because it is the 38 council members who, after being elected, come together and they decide among themselves who should be the office bearers. And that decision is more often than not made in an assessment that they would make over many years, because before a person becomes an office bearer, he or she would have served the Bar Council for nothing less than 6 to perhaps even 8 years. So members in council who have worked with them would be able to assess and come to a conclusion as whether this person is not just a person who makes good speeches, a person who just looks good and get things done for the betterment of the profession. And that's something, a system that we worked on, and that's another important aspect of that system is this. When the entire process of election takes place for the office bearers, it's not about which state you come from. It's no longer about that. It's about the person and the person who has contributed to the Bar Council and the work that he or she has done in Bar Council. We do not have, we do not identify persons with, which state they come from. But to our credit, the Malaysian Bar has had presidents from Johor, 2 persons from Johor, from Malacca, Perak, from Pahang, and that's the way the Malaysian Bar operates. It's a Malaysian bar. It's not a Kuala Lumpur bar, it's not a Selangor bar, it's a Malaysian bar. And we like to see our leaders come from any state within Malaysia. The present system, the difficulty that you have is if you have a direct election system based on popular votes, the spread is this. Kuala Lumpur has 7,000 members, and Selangor has 5,000 members, and the rest make up the remaining bar committees. In all likelihood, the leadership of the bar will be coming from Selangor and Kuala Lumpur, the largest bars, simply because they have the most votes. And that's not a healthy trend for the rest of the bar, because it simply mean that members, aspiring members in other states will eventually give up and say that it does not matter if people are just going to vote along state lines. It's something that we have dealt with in our present system, because in the assessment that council members make and that we don't take into account the state that you come from, almost anybody in council from any state can become an office bearer. And that's the system that we want going forward. And finally, the last proposal that we find objectionable, and these are proposals because it's still matters for discussion with government. None of these are carved in stone as yet. The last proposal is to empower the minister in charge of law to decide on the rules and regulations for the elections of the Bar Council, office bearer election, the Bar Council elections. Now that's quite untenable. You cannot have the executive deciding on the rules and regulations, electoral rules and regulations of a professional body. That certainly must be something that is left to the members of that body. If they don't like it, then they would move resolutions to have it changed. But if you have something like that, it will simply mean that the playing field can be changed as and when the person with the power to do so is not happy with the result that it is. So these are some of the proposals, and in a broad sweep, this cannot be seen in any other way than an attack on the independence of the bar. It would weaken the independence of the bar. It would paralyze us in many ways in the functions that we do. And in that sense, we will not be able to do a lot of things that we do today. And ours is just not the everyday professional matters, practice matters that we handle for our members, and which are important, obviously. But we also have a societal or public interest role, legal aid, law reform, and a whole slew of things that we do. And if these proposals go through, I dare say a restructured Bar Council would not be able to perform all those functions that we have been performing in the past 70 over years of our existence as an independent bar.
Is there a time frame that we're looking at for these reforms to move forward, or what is the scale that we're looking at in terms of time?
We've been informed that government intends to table these proposals in Parliament in October session of Parliament. We are, as I mentioned when I started, that we are speaking to government. We are discussing the proposals. We are raising these issues that I've just mentioned, and many more objections that we have to the proposals. But we are not sure whether that will mean that it doesn't go to Parliament in October. So that's the timeline there. But in the meanwhile, I think what we are doing is we are really going nationwide, state by state, speaking to members of the bar, speaking to members of the public, briefing them on the proposals and the ramifications of the proposals. And one very important aspect of the whole thing, that this is not an exercise of self-preservation for the bar. It's just not about us. Yes, it is critical, our independence is critical to us, but it's actually critical to members of society as well. To explain to members about members of the public, why an independent bar is important. An independent bar is almost always the last bastion, the last gate between an individual facing the might of the state. If the bar is not independent, the bar is influenced or controlled by government in any manner or form, then citizens cannot expect to have the fearless defense, if you like, the fearless representation that they would want when they are faced with an authority, when they are faced with government in problems that they may have. And that's very important. We must understand that. That's really one of the main features and strengths of an independent bar. So that's a message that we want to carry, and a message that we are carrying now nationwide. And of course, let's also be very clear about this. The independent bar is an important feature when any foreign investor looks at a country, because it's a rule of law barometer. When a country is assessed as to whether or not it meets the requirements of whether it's a rule of law compliant country, one of the main things that one of the first things obviously is whether the judiciary is independent. And the factor that comes very close to that is whether you have an independent bar. And if there are question marks on either of those fronts, whether the judiciary is independent or the bar is independent, then the investor would have one reason or one further reason to say, well, maybe this is not a jurisdiction where I wish to invest funds because my investment, if it is in jeopardy, who do I turn to? So that's again another message that we are carrying around the country, speaking to members of the public and members of bars. We have done so far Terengganu, Pahang, Malacca. I did Selangor yesterday, and I think we've done Perak and Scampi.
And if people want to know more about this, is there a website or something they can go to?
It's on our website, the Malaysian Bar website, and we are issuing periodically statements, keeping members of the bar. And our forums we are preparing web reports on our forums. Members of the public are invited to come to the forums. So that is there. But I think one aspect of the question is what can members of the public do?
Yes.
And I think that's a good way to round up on this question. I think you need to speak up. Members of the public need to speak up. An independent bar is another institution of the state. We live in a democracy. And in a democracy, there are a number of institutions of state. And in the past 10 months or so, we have seen a number of our state institutions, as it were, democratic state institutions, come under severe attack and challenge. The attack has now come to the bar. And the bar exists just not for ourselves, the lawyers, but we exist for society. So members of the public must speak up very strongly and say that we want an independent bar. The bar is not averse to reform. If there are any shortcomings in the way we operate, we're certainly open to ideas as to how we can reform ourselves. But interfering with the manner in which we manage ourselves, curtailing our independence is not good for Malaysia. It's not good for Malaysia, it's not good for the citizens of Malaysia, and it's something that members of the public must speak about and speak out strongly, about it, and hopefully government would listen to this and move away from these amendments.
Just one final question, and firstly, I must thank Joseph Gill. Thank you for this very important and pertinent question. I think it's the most important issue affecting the Malaysian bar right now in this country. Now, you've talked about Malaysians speaking up about these and objecting to it if it's going to affect their lives and the way this country is administered. Has there been any international commentary or outcry even about this?
Thank you very much for asking that question, Chacko, because I forgot about that. And how would I? We've had close to 14 organizations, both international law organizations as well as national law organizations, write to our Prime Minister, raising their concerns and objections to these proposals. And in each of these statements, you see them speaking very strongly about the need for an independent bar. Some of them have even spoken about the fact that our country must be concerned about an independent bar simply because it will affect investment into the country, foreign investment. And we've actually got a united voice in all these organizations. The last being just a couple of days ago, the Finnish Bar Association.
Okay.
And so and I expect more organizations to come on board and give their support to us as we stand for the independence.
Do you want to name some of the organizations?
Oh yes, sure. Law Asia. Let me give you a roll call of all the organizations. I've just updated it yesterday. Law Asia was the first organization to come up in support of the bar. Then we had the Law Society of New South Wales, the Faculty of Advocates Scotland, the Bar of Northern Ireland, the Bar of England and Wales, Law Society of England and Wales, the German Federal Bar, the Hong Kong Bar Association, the IBA, the International Bar Association, Law Council of Australia, the Australian Bar Association, the Commonwealth Lawyers Association, CLA, the Bar Association of Sri Lanka, the Finnish Bar Association. And I'm told that we will soon be expecting letters of support from the Taiwan Bar Association and possibly from Japan as well.
Okay. Well, that's good to know that we are getting support from outside, and now we want support from Malaysians out there.
Yes.
This is your bar, and they're here to protect your interests. Moving on to the next question, and this may be one of the reasons why the legal profession is under attack. This is a question by Robin Choi, who might be familiar to some of us. And her question is, what is the basis for the Malaysian bar to sue the Attorney General and ask for a judicial review on his decision to close the investigations on the PM regarding 1MDB? And what is the decision on that suit?
Okay. Interesting question, simply because I've just come from court, and we had the hearing today for our leave application for the judicial review. It's continuing. I think a decision will be made at a future date. But just some very brief history on this. Going back to July last year, and when we had the entire disclosures from Wall Street Journal and Sarawak Report on transfer of funds and 1MDB, the bar came out very strongly. Number of press statements that are issued on behalf of the bar, and in those press statements we express deep concern over the events and the fact that there should be full and thorough investigations into the allegations. We drew no conclusions as to culpability of anyone, but we emphasized and reiterated that there should be transparent and accountable investigations into these matters. In the process, we saw a number of our institutions, the MACC, the Attorney General's Chambers, the Police Force, Bank Negara Malaysia, a number of these institutions come under tremendous pressure. There were reports of arrests, the person being detained upon arrest, raids on property and so on. And in our press statements, we again said that these are institutions, and these institutions must be independent. The integrity of these institutions must be protected, and these are institutional state. Matters somewhat came to a boil in September. On the 12th of September last year, we called for an extraordinary general meeting of the Malaysian Bar. We had over 1,000 members attend that meeting, and at that meeting we resolved to condemn these acts of interference and attacks on independent institutions of state. And we also passed a resolution mandating the Bar Council to take legal action against any person, anybody who are interfering with the investigations, or who had interfered in the investigations, and take necessary legal action in respect to that matter. So that was in September. Fast forward September, we had 26th of January 2016, where we had the Attorney General come out with his decision on the matter, where he purported to exonerate the Prime Minister of the allegations, and he purported to direct the MACC to close their files. We had a difficulty with that, so we came up with a press statement publicly asking the Attorney General to reconsider his position, given that so much material out there, and it appeared to be a rather premature position, and also expressing our concerns about whether or not the Attorney General was in a position to exonerate anyone who is accused of a crime. There was no response from the Attorney General, so we filed the judicial review action, and that action is really to have our courts decide whether it's within the power of the Attorney General to exonerate a person who has been accused of a crime, as opposed to the Attorney General taking the position, which is the normal position, that there is either insufficient evidence to prosecute the case or sufficient evidence to prosecute the case. But here we had the next step, which was, in our view, an exoneration of the allegations. Exoneration is a matter for the courts. Matters of guilt and innocence, acquittal, or judgment, finding of guilt, is not a matter within the purview of the Attorney General, no matter what powers he has, no matter how broad the powers he has in terms of prosecution. So that's the first complaint we have raised in the judicial review action. The second complaint we raised is with regard to the directions given in his decision to the MACC to close their files. Again, no matter how broad the powers of the Attorney General are under our Constitution, we take the view that it's not broad enough for him to instruct an enforcement agency to stop investigations. On that basis, we commenced judicial review against the Attorney General and the MACC, and that matter is now in the courts. We await decision. And one of the reasons why we took that action, particularly in respect of the Attorney General's powers, notwithstanding there being a number of cases in Malaysia where our courts have said those powers are not within the judicial review jurisdiction of the courts. There are cases. But there are also decisions, certainly in other Commonwealth jurisdictions, where the courts have taken the view that the Attorney General's powers in respect of prosecution is open to review under very limited circumstances. And we find that our case may fit within those circumstances, and we want our courts to decide this matter, whether our courts want to stick with the law as it has been in the past, and we have cases perhaps going back to 30 years, or whether we want to move along with the other Commonwealth jurisdictions to see whether the prosecutorial powers of the Attorney General are open to review. So that's really the exercise, and if we succeed, then what happens is that the court then would require the Attorney General to reconsider his position and decide whether or not he should prosecute. We have not sought any order, and I want to make that clear, we have not sought any order from court for any particular person to be prosecuted. It's our view that that is a matter for the Attorney General. The position we take is that there's sufficient material out there, and certainly material that now we put before the court, that will warrant the Attorney General reconsidering his decision to decide whether or not he should prosecute.
Thank you for that very comprehensive summary. And just to do a little throwback to the previous question, if the reforms proposed to the Legal Profession Act had come into place prior to this, would the bar have been able to do this kind of application?
Okay. The answer is really yes, because if you look at the powers that the Bar Council has, one of the powers that we have is to really commence legal action within the LP as it stands. That power is intact. But lawyers being lawyers, in abundance of caution, because this is unprecedented, Chacko.
Okay.
You've been a member of the bar before, and unprecedented because the Malaysian bar has never embarked on a judicial review action against the decision of the Attorney General. It's the first time we're doing it. So we felt that it would be good that we actually have the issue discussed at our general meeting. Although at that time we were not talking about the judicial review in all fairness, we were talking about legal action, any appropriate legal action. So we got the general mandate, and then we moved on to the general mandate. But fast forward, if the amendments are in place, and let's say there is a requirement to get mandate from the House, we'll have a difficulty now, because with the proposed amendments, you need 25% of members to be present before we get a quorum, which means it's for 4,000 members, and that will be a difficult number to achieve. And if you don't have that number, then the EGM cannot be commenced, cannot be convened, and we won't be able to have discussed and resolve these matters.
And what about the proposal to have members of the government sitting in the Bar Council?
Okay, that is really a quite unacceptable proposal, obviously, because if you have members of government sitting in the council, and the proposal is that these persons will be representing government, and representation means that these persons would effectively have to report to government. Now that simply means that all our deliberations in the Bar Council are no longer confidential. And how that works out is this, because we deal with a number of issues. Of course, most of our time are spent on practice issues. Members of the public must not think that when the Bar Council meets, all we do is we talk about public interest, rule of law issues. Yes, those are important issues. But 80% of our time is actually taken on all many, I hesitate to use the word mundane, but they can be mundane. These are your run-of-the-mill, everyday issues that face our practitioners. But then there's 20% of matters where there are rule of law issues. Let's take an example, the Sedition Act. And there could be a very robust, open debate about the Sedition Act as to whether we want to accept the amendments, whether we want to oppose the amendments to the Sedition Act, whether we want it to be repealed, and so on. And members will speak freely. And they will speak freely with the knowledge that what they say will not be taken outside, would not be misrepresented, and certainly not distorted. So, they would want that sort of protection, that sort of comfort, if you like. And that's how we've operated. And that process is a critical process, because the final decision, the value of the final decision lies in that robust debate. It's that process. It leads to that final decision. So if you have people who are all shying away from speaking their mind, worrying how these two persons who are not subject to confidentiality are going to take it outside and report who has said and who has not, what a person has said, distorting what he has said and exposing him to whatever sanction, then the whole process really breaks down. That's the problem that we'd have. We have these two persons going out openly and reporting to government as to what is spoken at our Bar Council meetings.
Okay. Well, now moving on to the administration of the bar. As president, this is a question from Jin Chi. What are your plans for changes that you want to bring to the bar and the Bar Council during the rest of your term?
Let me just say this, it's been a tough term for us simply because since we took over, we came into office last term in March 2015, we had a number of amendments. We had amendments to the Sedition Act. We had the Prevention of Terrorism Act, POTA, and these are severe rule of law issues that we had to handle, and issues that we had to again go to the ground, state by state, explaining to members of the public. And then those are very challenging issues, and those issues still remain there. And then now we've got this LPA amendments and other rule of law issues, including the National Security Council Act, another major issue of concern to us. So these issues have occupied a lot of our time. But notwithstanding that, we have not lost sight, we have not ignored the concerns of our members. One chief concern, a complaint, if you like, that we get from either members of the judiciary or members of the bar, members of the public, is standards within the profession. So this year at our general meeting at AGM of the bar, we put in place a continuous professional development program, a CPD program, and we made it mandatory for lawyers 0 to 5 years. And that's just a beginning. We tend to then move to other sections of the bar, 5 to 10, and so on. I want to see that really take root in the next 6 months. Put that in place, because we need to move on with that, and that's good for the bar, because the bar is actually looking at itself and declaring that we will not remain stagnant or static in terms of standards. That we would ourselves regulate and put in place a program that will enhance our quality as lawyers, which in turn would of course enhance the quality of service that we will give to members of the public. So that's one critical area that's at the moment that we're looking at. Then we have also been working with the Attorney General's Chambers on another structure of practice. At the moment, we have sole proprietorships and partnerships. We are looking at a new structure which is called limited liability partnerships, which will allow partners to limit their liability in particular circumstances. That's there, so we're hoping to see an amendment to the Legal Profession Act have that in place. They give another option to our members. We also are working on our liberalization scheme. It's a scheme that came into being about 2 years ago. At the moment, we've got one foreign firm here, and we're looking at other foreign firms who have applied. And the importance of that is, with the foreign firms being in our jurisdiction, with them comes the work, with them comes the possibility of really enlarging the pie, if you like, for even our lawyers to participate in that kind of work, different areas of work. With them comes the possibility of technology transfer, all of which are good things for a progressive modern profession. And it's things that we, the liberalization of legal services is a thing that has happened in Singapore for a number of years, and in other jurisdictions around us. We are pretty much playing catch up, but we see the benefits of that in Singapore and in Hong Kong, and we want to have that benefits as well. And one of the key things about liberalization of our services, legal services, is the way in which we have handled arbitration. Today, by the amendments that we have put into the LPA, and we're happy to see that our arbitration, the KLRCA, is a center that's an international center that is open to a litigant, international or local litigant. He can have his own arbitrators, he can have his own set of lawyers. They walk in freely, and arbitrations are conducted at the KLRCA in that manner. So that's actually a very good thing for the country to have that kind of work coming to the country. Then there are other things like we have conditional fee rules. We've always been grappling with contingency fees. So we are looking at a conditional fee scheme that will allow our lawyers to take on work that they will otherwise not be able to take on. Then we are looking at our solicitor's remuneration order on conveyancing matters. At the AGM in March, we passed a resolution to allow our lawyers to give some level of discount in the fees they charge. So that will make it a bit more competitive for our lawyers to take on work. And small firm practice, that's another thing that we're looking at. A small firm practice, which is a loose association of law firms within a building where they share certain resources to keep their overheads down. So those are some of the things that we want to see in the next 6 months, and I certainly want to see them happen in the next 6 months.
Okay. Is that when your term ends?
Yes, my term ends in March 2017.
Okay.
By law, it's a 1-year term, and then you are eligible for re-election for another term, or maximum. So it's a maximum of 2 years.
2 years.
Yeah.
Okay, we've seen and heard about the plans that the government has for the legal profession, and what Steven as president and the bar itself has for its members. Now let's look at what the Chief Justice, Tun Arifin Zakaria, proposes for the separation of judicial and legal services under the Judicial and Legal Services Commission. They're currently both headed by the Attorney General. Does the Malaysian Bar Council have a role in this? And could you enlighten us as to the rationale behind this proposal? This is a question from Justine Chu. Thank you, Justine.
Okay, this is not a new proposal because this issue has been around for, I think, about 30 years now, and the bar has consistently taken the position that the Judicial and Legal Services Commission should not be in the manner that it is today, fused as it is, because you have a bit of an anomalous position where, for example, you have a person in the sub-courts, Sessions Court judge, presiding over a matter where technically the Attorney General could turn up, and the Attorney General is the ultimate superior of that Sessions Court judge. So with that comes a whole host of concerns, as you can imagine, and we want to avoid that. So we've always spoken very strongly about having a separation between judicial and legal services. The legal services, meaning the public prosecutors, the legal advisors in the government and governmental agencies, they can very well come under the Attorney General's chambers or under the Attorney General. But in terms of legal services, which is any person who occupies a position in the judiciary, and here we are really talking about the judiciary in the subordinate courts, then these persons should not come under the purview of the Attorney General.
So there's a judicial services.
Yes, judicial services. They should come, really strictly speaking, under the judiciary, within a judicial commission in that sense. So there is a clear separation between legal services and judicial services, and we'll never have this kind of problems that we have about a superior having to decide a case, a subordinate person sitting as a judge having to decide a case facing his or her ultimate superior as the advocate before. So when Tun Arifin spoke about it recently, the bar came out in support, and we were really not saying anything new. It's something that we've been saying for a long time.
But it's good to have support from somebody as
Yes.
important as
Yes.
the Chief Justice.
Yes.
It's keeping in line with that topic. Surin had raised some issues about the judiciary, and what are your views on, say, the appointment of judges?
Thank you. That's again a very important question, because if we look to the manner in which we appointed judges, say pre-2006, we didn't have any fixed structure in place, and that led to a number of concerns. And these concerns manifested themselves when we had the problem in 2006 about for justice, the disclosures that we had in the tapes. There was a Royal Commission of Inquiry, and after the Royal Commission of Inquiry, the good thing that came out of it, the bar supported this, is that now we have a Judicial Appointments Commission in place. And with the Judicial Appointments Commission, there is a structure by which individuals can be appointed as judges, judicial commissioners first, judges of High Court, and they move on. It's all within that commission. So that's a good start. It's a good start to have a transparent decision-making process in the way in which we appoint judges. But there are certain shortcomings. We're certainly better off than where we were in the past. The shortcomings are A, if you look at the constitution of the commission, they're all judges or retired judges. So it's a case of judges appointing judges. Good as a start principle, but something that we need to evolve from, we need to move away from, because if you look at the other jurisdictions, they moved away from that. And we have started that way, but today the Judicial Appointments Commission in many jurisdictions have the input or participation of the key stakeholders in the legal profession. So you have, for example, the Attorney General's chambers represented in the commission, the President of the Bar, Chairman of the Bar, indeed even other civil society organizations, because everybody's a stakeholder in justice, and judges are there to dispense justice. That's the next step we need to take in terms of how we reform the constitution of the commission. Then the other shortcoming that we have, and it's a serious shortcoming, is today it is the Judicial Appointments Commission would identify a candidate, they would interview a candidate, and then a recommendation is given to the Prime Minister. And the Prime Minister could very well just say, can you give me another name? Which means that the first name that went forward is effectively rejected, and no reasons are given. So it all really goes to a bit of a bottleneck with the Prime Minister, and then the appointment may or may not take place. We think that is not a good practice. While the Prime Minister may well have a role in this, but if the Prime Minister has concerns, and that's a concern for the government, then that concerns must be communicated to the Judicial Appointments Commission. So if a name is put forward to the Prime Minister, and the Prime Minister and the Governor of the day has an objection for that person, it could be a security reason, nobody knows about that, and that reason is given to the Judicial Appointments Commission, well, they can accept it. But if the reasons are reasons that do not stand up to scrutiny, then it's the Commission's view that should prevail, and not the Executive's view. And the Commission's view then should go forward. In our system, it goes to the Conference of Rulers, the Conference of Rulers, and the Conference then decides. In fact, that is very much in line with the proposals that the Bar made, because not all our proposals were adopted when there were discussions to form the Judicial Appointments Commission, And that is one of our proposals, that if the Prime Minister had misgivings about a particular recommendation given by the JAC, then he should actually state his objections in writing, and the JAC must then consider the objections, and if the JAC decided that those objections are not acceptable, then it's for them to reject it, and it moves.
Okay.
Yeah.
All right, just a quick bit of information for those who have joined during the session. We started at 3 o'clock. This is HAKAM's Ask Me series, and we have Steven Thiru here, President of the Malaysian Bar, answering questions that we've put on HAKAM's Facebook page. I'm Chacko Vadaketh, and we have another 15 minutes or so left for the session. And moving on, we've talked about the Legal Profession Act and the amendments to it, which are perceived by many to be threats to the legal profession's independence in particular. We've looked at appointments of judges, and to round up the session, let's look at lawyers and new lawyers coming into the profession. What do you look for in accepting a chambering student or when you're choosing a junior lawyer, Steve?
Okay, obviously to cross the first door, you must have the requisite qualifications, and it varies from firm to firm, and it's the training that you've got, university that you've gone to, and the undergraduate degree. And of course, most firms would look for graduates with a minimum of second upper or equivalent in other jurisdictions. We've done a survey, and it's a survey that many employers, including my firm, adopts. We would really look at graduates who have got excellent undergraduate qualifications, the second upper or the equivalent, and we look at their bar training. And today, the gold standard, if you like, for bar courses is either the bar professional training course in the UK or the College of Law in Australia. So those are really we find even in the survey, those are first pick, and that really gets you through the door. And then what happens after that? What we look for, and you really look for attitude. At that stage, it's not a question of your knowledge of the law. It's an assumption that you've got the requisite qualifications and everything else will fall in place. Attitude meaning the willingness to learn, the willingness to work hard, long hours, the willingness to make mistakes, to ask and make those mistakes, provided those mistakes can be contained, because you are in a profession, and there are ramifications if you make mistakes. But that's fine. But that attitude is important. I'm happy to say most of the people we interview have those attitude, that levels of attitude. Yeah, you may have those extreme cases, the persons who don't make it. The other important thing, which is becoming really a challenging thing for most employers, is language skills. And we find that many of the persons who come for our interviews have difficulty conversing fluently, either English or Bahasa Malaysia, and that's not a problem for us. Really, you are meant to be bilingual in this country, and ideally, in an interview, we'd like to speak to somebody in both languages, because speaking as a litigation lawyer, many of these young lawyers would be first cutting their teeth in the subcourts where things are going to be in Bahasa Malaysia. So you must be fluent in Bahasa Malaysia, and of course in English, because the language of commerce remains English, and you're a lawyer. You're going to have to be speaking to clients, and with language comes a level of confidence both in yourself and the client in you. And we find that lacking for one reason or another, that the language skills are not quite up there. So I know a lot of firms that, and this is a good thing, they do not on the face of it disqualify a person simply because language is not totally up there, up to the mark. They're willing to give them a chance. It's a good thing. They give them training. Others may not do that, but it's a problem. So my advice would be these two things. One is your attitude must be right. You must show that humility willingness to learn, willingness to work very hard, put everything aside, focused on what, and we all had to go through that. That's really no magic that we all had to go through that route. And then the other thing is your language skills. You must be able to come across as somebody who can speak fluently in both English and Bahasa Malaysia. That's critical to practice in Malaysia. Yeah.
We're talking to Steven Thiru, President of the Malaysian Bar, on the HAKAM Facebook Live series. Please share this live feed on your page, tag friends of yours that might be particularly interested in this, and of course the whole session will be available for you to view at your leisure once this is over. Next question, Steven. Based on the Malaysian Bar website, there are 17,214 lawyers in Malaysia. Looking at the fact that we have some 29 million people, do you think the number of legal practitioners are sufficient to deal with the legal cases in this country? Thank you, Ng Seng Yi, for this question.
Okay, one thing there first. That number only represents lawyers in West Malaysia. There are, I think, further close to 3,000 lawyers in East Malaysia. So in total, we have something like 20,000 lawyers throughout Malaysia. The numbers in East Malaysia are small, given how big those two states are. In terms of West Malaysia, the concern, the challenge that we have is this. If you look at the spread of lawyers, the concentration of lawyers is at the moment in the Klang Valley. When I say Klang Valley, of course, Selangor and Kuala Lumpur. Selangor and Kuala Lumpur would contribute something like, I think, close to 12,000 out of that number you just mentioned. 11,000, 12,000. The remaining are spread around the country. So in terms of Kuala Lumpur and Selangor, yes, there's a level of saturation. It is very tough. Competition is tough. But once you leave Kuala Lumpur and Selangor, then there's actually a need for lawyers outside. In the rural areas, in the smaller states, where the numbers are very small and there is I think, sufficient work. That's the problem. Of course, you have lawyers from KL and Selangor moving out to do the work in the other states, but if you look state-wise, then the numbers are small. But the downside is this. While the numbers may be big, I'm sorry to say the standards are not to the level that we would want to aspire to. That's a challenge for us. And it's all so easy for us to just blame other lawyers. But the problem is far more complex than that. We have a system at undergraduate level, and I'm not just talking about Malaysia, I'm talking about really undergraduate level, and we see this throughout the other jurisdictions that from where our lawyers come from, that do not really do our lawyers any favors. Training standards are not as good as they should be, so they come into the profession rather ill-prepared, and then into a system that not often or always gives credit to quality and merit. So that's a concern, that's a problem. So standards in that sense becomes a major issue for us. So it is quite common for people to say public perception, rightly or wrongly. While your numbers may be big, but quality is not there to match those numbers. You may have 17,000 members, but how many really good lawyers do you have? And that's always a very difficult question to answer. I like to say that most of our lawyers are very good lawyers. They stand with among the best in the world, but we really can do better. So I'm not too concerned about the numbers. It's about 17,000. It must be a manageable number. Access to justice means, of course, you must first have a lawyer, and secondly, you must have a competent lawyer to do the work for you. But I would be more concerned about quality. I would be more concerned about how we can enhance quality and moving forward deal with the kind of problems that we've had in the past.
I think this nicely leads us on to the next question, also by Ng Seng Yi, which is about the mushrooming of law programs provided by private universities in this country. Is this a positive trend, in your opinion, Stephen?
Again, it cannot be a numbers question. There is a moratorium that has been put in place by the Legal Profession Qualifying Board on new law programs. So I wouldn't say there's really a mushrooming of programs. It's really within those programs that are there, you have new options. So for example, you have more cases of private law firms that would offer training programs with a variety of universities, particularly in the UK. That's there. We are seeing an increase of public universities. We had the traditional 4, and with the traditional 4 now we have 3 more, so we have 7 public universities, law faculties in public universities. The last 3 being University of Utara Malaysia, Multimedia University, Melaka, and the Uniza, in Uniza University in Terengganu. It cannot be a numbers game. It's the same point I would make. We are concerned about quality. We are concerned about standards. And we are concerned that there should be uniform standards. Today, the real difficulty is that with these different numbers that we have, public universities, private local colleges, foreign universities, and if you look at the legal profession, the LPA, in terms of entry into the profession, there are no less than 7 routes of entry into the legal profession. 7 different jurisdictions, if you like, of qualifications to come into the profession. Now, as you can imagine, with that 7 routes come seven different types of standards and quality, varying from the good to the not very good. That is something we want to deal with. We want to have a common entry program where no matter where you come from, there would be a standard training before a person is admitted to practice. We call it a common bar course. It's something that we've been working on for, I think, 14 years, 12, 14 years. And we hope to see that in place at some time, because that's really the next level in terms of quality law programs in this country. The program, whatever the training is at the law programs, the next level must be practical training.
Thank you, Stephen. You've been listening to Steven Thiru, President of the Malaysian Bar, talking to you, watching this on Facebook Live, on HAKAM's Facebook page, answering questions that you've posted. This whole interview will be posted on the HAKAM Facebook page for you to view at your leisure later on if you've missed any part of it, or if you'd like to share it with friends of yours who might be interested in watching this. Marina Mahathir would be our next guest on the 8th of September, Datin Paduka Marina Mahathir, and please post your questions that you have to her. She's going to look at certain specific areas in human rights. And after her would be Professor Azmi Sharul. So look out for these interviews that are coming up on HAKAM's Facebook page. I'm Chacko Vadaketh, and I once again thank Steven Thiru, President of the Malaysian Bar, who's taken time from his very busy schedule, even coming out of court, where very important cases involving 1MDB and the Attorney General and the Malaysian Bar are being considered as we speak. So thank you very much for taking time and trouble to speak to our viewers here out in cyberspace. And thank you to all of you for joining us. Please share this with your friends and on your pages, and come back for our next 2 sessions coming up with Datin Paduka Marina Mahathir and Professor Azmi Sharul. Thank you and good afternoon.